Hello learners, welcome back to your education channel Learn and Educate, where we were studying Code of Civil Procedure 1908, under which Section 137, Language of Subordinate Codes, subsection 1. The language which on the commencement of this code is the language of any court. The language on the commencement of this code is the language of any court subordinate to the High Court shall continue to be the language of such subordinate court until the state government otherwise directs them. Thus states that on the commencement of this code, the language of any court which is a subordinate to the High Courts, which means the High Court, all the courts which is subordinate to the High Court shall follow the language of the High Courts. Otherwise, until the state government directs, until the state government directs, the language of any court subordinate to the High Court shall be the language continue to be the language of that subordinate court. The language of High Court will continue to be the language of all the other subordinate courts until the state government directs. Subsection 2 states about the state government may declare what shall be the language of any such courts, and that shall be the language of any court, and the character applications to and the proceedings in which court shall be written. The state government may declare what shall be the language of any such court and in what character applications to and the proceedings in such courts shall be written. Subsection 3 states about where this court requires or allows anything other than the recording of the evidences to be done in writing in any such courts. Such writing may be in English, but if any party or his pleader is acquainted with the English, a translation into the language of the court shall be at his request be supplied to him, and the court shall make such order as it thinks fit in respect of the payment of the cost of such translation. Where the court requires where the court requires the evidences recording of evidences to be done in the writing of any such court, then such writing shall be made in the English. But if any party or his pleader is not acquainted with the English, a translation shall be made into the language of the court at his request and supplied to him, and the court shall make such order as it thinks fit in respect of the payment of the cost of such translation. Section 138 states about power of the High Court to require evidence to be recorded in English. The High Court may, by the notification in the official gazette, the High Court will be informed by the notification in the official gazette direct with respect to the judge specified in the notification or falling under a description set forth therein that the evidence in the case in which an appeal is allowed shall be taken down by him in the English language and in the manner prescribed, that the High Court shall direct by notification in the official gazette with respect to any judge specified in the notification or falling under the description set forth therein that the evidence in cases in which an appeal is allowed shall be taken down by him in the English language shall be taken down by him in the English language and in the manner prescribed. Section 138 subsection 2 states where a judge is prevented by any sufficient reasons from complying with the direction under subsection 1. When the judge is prevented by sufficient reasons from complying with the directions stated in subsection 1, he shall record the reasons and cause the evidence to be taken down in the writing. He shall record evidences and taken down in writing from his dictation in the open court. Thank you for watching.